I tell young lawyers, one of the most important things that you have to do is, if not make friends, avoid making enemies. If you want to be a judge, you have to fill out this long, complicated, humongous application to which you are required to append the names of 50 lawyers who are familiar with your work. God help you if you don't have 50 friends, or at least 50 people that aren't your enemy, who will fill out forms. Your life is just so much better if you're good to people.
Howdy, and welcome to the show. Cooper's Code focuses on legal issues and notable practitioners, distilling wisdom so we all achieve the best results for our clients. I'm Miles Cooper, and I'm thrilled to share this conversation with Justice William Bedsworth. Justice Bedsworth is best known, probably, for his long-standing 44-year running column that has now been syndicated nationwide. His humor and his approach to life is one that people throughout the legal community are likely already aware of. Justice Bedsworth initially started as a district attorney in the Orange County DA's office. He focused his career on writs and appeals and was elevated to the bench and ran for judicial office, winning a seat as a trial court judge in Orange County, where he sat for 9 years in criminal and 1 year in civil before being elevated to the California Court of Appeals. Other items of note: having served as a gold judge for the Anaheim Ducks, having written some of the seminal opinions on civility in the courtroom, as well as seminal opinion on LGBTQ rights. So, without further ado, please join us for this marvelous conversation with Justice Bedsworth. Welcome to the show, Justice.
Thank you, Miles. I appreciate the invitation.
And for those wondering about the chuckle, before we started, we had a little conversation about what honorific or name one should use with someone who has come off the bench. So why don't we start a little bit in terms of your background, how you ended up going to law school and becoming initially a DA.
I grew up blue collar, and in post-war blue collar families, the dream was that the son would become either a doctor or a lawyer. I was not good at math and science. I was not interested in math, and a lot of science was math. So it was decided I was going to be a lawyer very early on, and I never questioned it. If I'd had a decent high school guidance counselor, I would be doing play-by-play for the Lodi Crushers today. But that was not a perceived career path for a smart kid in a blue-collar family. So I always assumed I would be going to law school.
Where did you grow up?
I grew up in Gardena, which is a little suburb of Los Angeles. People familiar with the area will know the larger suburb of Torrance, and the beach cities, Redondo Beach and Manhattan Beach, which Gardena is close to.
When you finished law school, did you have an idea of what direction you planned on going?
No. Well, by the time I finished, yes. I aced my first year. Came home and told my wife, we're going to be rich. It turns out I'm really good at this. For various reasons, I did not clerk my first year, and then went back for my second year, and I was taking corporations, remedies, UCC, and something else equally dull, and hated it. I kept thinking, I not only didn't go to law school to try to save GE $20,000 on their taxes, I rather hope it can be done. I was bored silly, and I stopped going to class in November and went back and tried to line up some other kind of employment. I went back to my college to see if I could teach English. I talked to my college baseball coach, who said, I don't have a budget that's left for another assistant, but St. Mary's in Moraga is looking for a head coach. You should talk to them. And I interviewed at St. Mary's a couple of times, and I was that close to being the head baseball coach at St. Mary's, which also involved field maintenance and teaching one class. And I went to dinner with a friend of my wife's and her father. And after we talked for a while, he said, anybody who likes to eat as much as you do should get a job where he can afford food. And this coaching gig is not going to do that for you. Go back to law school, catch up on your classes, take your finals, drop all those classes that are boring you for the next semester. Take 4 things that sound interesting. I took sports and entertainment law, international law, labor law, and criminal procedure. And I fell in love with criminal procedure. And so I started taking all the criminal classes I could find. Now I was interested again. I came out, got a post-bar, pre-results clerking job with the Orange County DA's office, close to home. It's where my roots were. And I came back and started working for the Orange County DA's office.
In today's era, a lot of people who want to become DAs find that unless you get started early in the process with an internship, or you're willing to move up to some county far north or somewhere where people don't want to live, it's really hard to get a DA job. Was it like that back then?
No, it was not easy because this was a perceived route to litigation. You would learn to try lawsuits in the DA's office, and then you would go into civil practice. And now that you knew how to try a lawsuit, you would get rich. And that was the goal. I was lucky enough to get the job. The 3 people who interviewed me for the last time. There was a 3-interview process to get the job. At the end of the interview, one of them said to the other, and I found this out years later, one of them said to the other, hey, I'm late for lunch. You guys hire whoever you want to hire. These last 3 are fine. Well, except for the fat wimp. I was the fat wimp. And one of them said, Dick, he can't be a wimp. He was a Division I catcher. You can't catch college baseball and be a wimp. And the first guy said, okay, if you want to hire the fat wimp, that's okay too. And so my 3 years of law school, my writing sample, my references, none of that helped me. I got the job because I'd been a backup catcher at Loyola. The weird things that shape your life.
2 different directions that I want to go down with that. And the first is, how did you find out that that was what was said?
Oh, years after, one of the interviewees said, funny story about your interview, and told me. By the time, we were both judges. The funny thing is, the guy who said, don't hire the fat wimp was, as it turns out, absolutely correct. I didn't like litigation. I wimped out. I am a failed trial lawyer. I grew up fat, poor, and with glasses. You don't build up a lot of self-confidence. My athletic skills and my academic success kind of evened things out for me and helped my own psyche, but they never made me at ease with meeting people. I am marginally phobic about meeting people. And that's all you do as a litigator. You meet the new judge, you meet the witnesses, you meet the police officers if you're a DA, and then you have that world's worst cocktail party called voir dire, where you meet 60 strangers and try to talk to them about their lives long enough to get a sense of whether that's somebody you want on your jury. Stranger after stranger after stranger. I did not like it. And I was going nowhere. I was good at it. In fact, they sent a litigator to watch me. One day I looked up and one of the top litigators in the office was in the back of my courtroom while I was trying a driving under the influence case. And I came back to my office at lunch and he wasn't there. I came back to court after lunch. There he was in the back of the court. I came back to my office and there he was. I sat down and before I could say anything, he leaned forward and said, "Why don't you like this? You're good at this. Why don't you like doing it?" And I lied. I said, "Oh, I like it fine, John. I don't know what you're talking about." He said, "Your stats make it clear that you don't like anything. We've looked at the dispositions that you've entered. You're not giving away the store, but you are only going to trial when you have to go to trial." And I had to admit, yeah, I was not comfortable doing that. And he shook his head and said, "Well, you're good enough at it that we'll find something else for you to do until you feel better about it." And they put me into their section that they called writs and appeals, which did writs and appeals, but they had me doing felony law in motion. And I was a pig in slop. I was going out there every Friday with a brief I had written and arguing to the court for 15 minutes or putting on a 1538 and interviewing one or two witnesses. I was a happy camper and my career took off.
Interesting. How long was it before you found kind of the right path within the DA's office?
5 years. It was 3 before I got to felony trials, which was a long time to be doing misdemeanors. They finally said, we got to give this guy a shot at felonies. And I did fine trying my felonies. But when I got to felonies, I met the people who were doing felonies. And they were the ones who said, "Hey, put him into writs and appeals. It'd be fine in writs and appeals."
One of the things I want to go back to is your comment about the world's worst cocktail party ever, voir dire. We're fast forwarding a little bit. Getting on the bench was something that you strove for and ultimately ran for and won. And I think of particularly a trial judge. One of the things that there's a lot of is voir dire. So how did those two work for you?
Juries love me. Juries love all judges, really. Something all attorneys have to keep in mind is if you are perceived as being disapproved of by the judge, it really hurts you. When they get back into that jury room, if you're the guy who was fighting with the judge, you've got a problem. Yeah, if the judge is a jerk, then it evens out and you don't have a problem. But you're not going to run into many who come across to the jury as jerks. I loved voir dire when I got to just joke with the jury for a few minutes to try to put them at ease and then turn the attorneys loose. I used to start every day with a this day in history, but the this day that I chose was always offbeat stuff. There was a radio station in Texas that banned Beatles songs, said they are not going to play any more Beatles songs. And that night, their tower got struck by lightning. I collected a bunch of things like that, and I would start out with that. And I started every day of trial throughout my life, throughout 37 years on the bench, the same way. Good morning, ladies and gentlemen. Welcome to the Hotel California. There was a method to that madness. It always loosened people up. It always made the people who were nervous about court and with jurors absolutely intimidated by court relax a little bit and feel like, okay, this isn't going to be as bad as I thought. Relaxed lawyers do a better job than nervous lawyers. And in the Court of Appeal, I always felt like, okay, this relaxes people. This will help their performance. I would open with that. I would tell them the day in history thing, and then I would remind them, okay, you've had some fun. Now we're going to get into the serious part. We're going to get back to our trial. Ms. So-and-so, call your next witness. And lawyers liked coming to my courtroom. Defense lawyers especially liked it. Criminal defenses. I did, for the 10 years I was there, I did 9 criminal and 1 civil. The word on me was that I had a nice, relaxed view of relevance. If you were a criminal defendant, you were more liable to get your evidence in front of me than you were in front of other people. I was not a good judge if you were going to lose, for sure, because I was not a good sentencer for the defense. But if you had a shot, I was a good place to be.
Not a good sentencer for the defense sounds a little euphemistic. Does that mean that if somebody was convicted, it was going to be a bad day for them?
Yes.
Yeah.
I didn't intentionally do that. It was just that I guess I was more offended by things than some. I looked at the statute and it said 135, and I said, okay, this was a middle of the road one, so he gets a 3. And I was hard to talk out of that.
With 9 years in criminal trials and all the work in the DA's office, did you find the exposure to some of humanity's worst impacted you in any way?
Yeah, it's impossible to do that job without becoming a little pessimistic about human nature, a little cynical. If you're aware that that's happening to you, or that that's something that could happen to you, you can deal with it. But I knew judges who'd been on the criminal courts for years whose view of human nature was pretty bleak. And I attributed it to that. We used to laugh about the poor forensic psychiatrists and psychologists who got up there, who spent their entire careers dealing with psychopaths. And, how in the world did they go into the market and deal with people? But 9 years on the criminal bench had an effect on me. Now, my 1 year of civil, the presiding judge and a friend who was a judge came to me and said, we know you want to be on the Court of Appeal. You've got 9 years of criminal practice. You were a DA for 15 years. You need some civil on your resume. We've created a job for you. You're going to be a civil overflow court. 5 days a week, you're going to do nothing but try civil cases. You won't have to deal with the pretrial motions. You won't have to deal with any of that stuff. We will just send you civil cases for trial. And, as I said earlier, you've tried criminal cases, you can try civil cases. The evidence code is the same. And they would send me civil cases. I didn't think about it at the time, but I think I was probably the most effective settlement tool they had ever had. The attorneys would answer ready, Your Honor, 6 weeks of trial, and the calendar judge would look at them and say, great, I have a courtroom for you. I have an ex-prosecutor who has never so much as seen a civil case, who will try your case. And what's more, he'll do it 5 days a week. So you won't be getting Fridays off. You'll be in trial every day. We'll knock that 6 weeks down to 3, and you will be done. And they'd say, Your Honor, we've been nursing this case for 5 years. We've tried and tried unsuccessfully to settle it. But if you'll give us 5 minutes without sending us to that ex-prosecutor, I think we may be able to work something out. And I mean, they were dealing cases in the calendar court like crazy as long as I was open.
That's funny.
I had a good time. And the civil bar took wonderful care of me. They knew that I didn't have the background. And they would come in with trial briefs. So help me, if I expressed doubt about what time we would start trial the next day, I would have a trial brief by the end of the day recommending whether we should start at 9 or 9:30. Uh, you don't get that in criminal trials. You're lucky if you get any kind of briefing, and sometimes the arguments you get do not really help you a whole lot. You have to wing it. Boy, those civil lawyers, they took real good care of me. It was nice work.
If you're enjoying what we're doing here with Cooper's Code, please help us extend our reach by giving us a 5-star review on Apple Podcasts and consider sharing an episode with a friend. Additionally, we want to know who you want to hear on the show. Have an interview suggestion? Email us at podcast@coopers.law. I jumped ahead to the discussion of the bench, and I didn't go into depth in terms of what you liked about the writ and appellate work for the DA's office. And when I say that, I'm having not done that job or talked to anyone who's done that job before. It'd be lovely to hear a little bit about what it entails and what in particular you liked about it. It sounds very research and writing intensive.
Yeah, it was, and that's why it happened. I was just very, very lucky. If you think about it, I mean, our office at that time was less than 100 lawyers. I don't know, 80, 90 lawyers. There were 95 of them who wanted to be in the courtroom, and 5 who were willing to sit in the law library and do that work and write. So I had my choice of competing for advancement with 95 lawyers or with 5. I didn't think about it in those terms. I was just thinking, oh, I like doing this. But it really helped my advancement. They needed somebody to do this job. The defense bar was bringing in experts by that time. 4 years, and it'll probably be hard for people who practice now to imagine. But back then, and we're talking the 70s, back then, the DAs would try their case all week, and then on Thursday night, they'd try to put together their law motions, their 1538s, their 995s, their Miranda issues, all that stuff that was going to be argued on Friday.
For those of us who spent all of our time on the civil side, would you just define that? Because that's the second time I think the 1538s came up.
That's the curse of the criminal lawyer. We do that all the time. 995s are motions to dismiss the indictment or information on the basis that there isn't enough evidence to support it. 1538.5s are motions to suppress evidence on the basis of a Fourth Amendment violation.
Okay.
And then there are the Miranda motions, First Amendment violations. That takes up most of the judge's Friday calendar. And that's what I was doing. And I was just as happy as a clam. I've told people for years about the appellate court that our court consists of 7 lawyers who write and 1 writer who practices law. I love to write. And here I had a job where I was just writing. Now, it did make me the Dalmatian in the room full of black labs. I was considered very odd by a lot of people, I'm sure, in the DA's office. I got a reputation as some kind of genius because whenever they had a problem on the Fourth Amendment or the First Amendment or whatever, I was the guy they came to. And they were good lawyers. There was no shortage of intellect there, but they weren't living the Fourth Amendment and the First Amendment as I was. I got to be extremely well-versed in search and seizure law and all those things. One of the things that drove me crazy about my career on the bench was that you don't get to be an expert anymore. It forces you to become a generalist, and you know less and less about the thing that you used to know inside and out. I went from being the guy that you went to with a Fourth Amendment question to being the guy who would say to his research attorney, okay, the law used to be X and then they changed it to Y. or it used to be Y and they changed it to X. Which is it now? What is the law on this point? And that's hard on your ego. You have to find yourself looking at the nameplate that says judge or justice to remind yourself, okay, it's not that I've gotten stupider. It's that I'm having to know a broader base of things.
I've talked with a few other judges on the show. I don't know that I've ever asked a question along the lines of defining what it means to be a judge. And specifically to this point of having been a master of the Fourth Amendment and then having become a generalist, do you consider the job of a judge or a justice to be a master of the law or a master of interpreting the advocacy that is put in front of you, or what?
The simple answer, of course, is it's both. Your instincts are right that those are both important things. One of the reasons people like to come into my court that was expressed to me by others was that I let lawyers try their case. You have to listen to what the lawyer is doing and let him or her go in that direction, whether you think it's the right direction, whether that's the smartest way to try the case or not. Part of your job is staying out of the fray. You have to be above it and running it. You obviously have to have a really good grasp on the law to be able to referee the contest. You have to know the rules really well, or you can't be the umpire. And knowing the rules is a big part of it, but the bigger part is knowing human beings and being able to distinguish between the lawyer who is being disrespectful and the lawyer who is just a jerk and doesn't really know any other way except this way. It's just the way he or she is. Not taking offense. You spend a lot of time with one side or the other telling you you're wrong. And you just have to learn to deal with that. I tell people the best grade we ever got on the Court of Appeal was a C. The lawyer who thought you got it right said, oh, A. Of course, I gave him the brief. There's no way this court could have screwed that up. A reasonably intelligent golden retriever could have gotten this right. The other side says it was a one-issue test and they got it wrong. That's an F. Well, you balance out an A and an F and you're a C. And, maybe you're a C minus if you said something they didn't like. The joke in the trial court has always been that every time you make a ruling, you make a temporary friend and a permanent enemy. And by the time the trial is over, the losing side is not crazy about you. And you have to be able to just deal with that. Fortunately, almost nobody who gets those jobs gets them without a big ego. And so it's easier to say, oh, he was just wrong. He was just a jerk. She just didn't know what she was doing. Whatever. But you have to deal with that.
I imagine on the criminal side, you're seeing repeat players, and I'm referring here to being in the trial courts. You're seeing repeat players on a regular basis. On the civil side, for the year that you did civil, is the Orange County bench or the cases that you saw small enough that you were also seeing repeat players, or was it bigger?
No, even then, and now it's much bigger, of course. The size of the bar, especially in a county of 3.5 million, the size of the civil bar is such that you never see them again. And that's one of the problems that we face now. I have become known for writing the Holy Trinity of Civility cases. I wrote 3 cases about civility. Very strange for me because in the criminal law, there was very little civility problem. Everybody knew, I'm going to be dealing with that public defender or that DA next week. That private attorney is going to be back in front of that judge 2 weeks from now. And civility was a matter of staying afloat. In the civil bar, where I'm probably never going to see this person again, we're running into a lot of people who think that bullying and intimidation is an easier way to win a case than being right. And unfortunately, in a lot of cases, they are. There are a lot more civil practitioners who've never tried a case or never tried more than 4 or 5 cases. In the DA's office or the public defender's office, you try 4 or 5 cases a month. And you become a lot harder to intimidate. In the civil bar, you can be intimidated. And I don't mean to suggest that the civil law is being practiced by a bunch of wimps. I just mean that people without experience are more likely to perhaps consider settlement than they would have been if they'd had more trial experience under their belt. And we are seeing, I was seeing before I left the bench, a lot more conduct that just can't be tolerated. It has to be stopped. And God bless them, my ex-colleagues are trying to do that right now.
Let's unpack the holy trinity of civility. Can you tell us a little bit about the cases and how those came to you and what impact you made?
The first one was a case called Kim versus Westmore Partners. And the main issue was default. There was a default judgment and it wasn't properly taken. And the first 10 pages of that opinion deal with that issue. But then we felt we had to address the incivility. And I said that for too long, our profession has talked about a golden age in which lawyers treated each other with respect. But for decades, we've been trying to get them to practice law the way it should be practiced. And we've given lip service to civility. And all those years of lip service to civility have gotten us nothing but tired lips. That's actually in the opinion. And this time we're going to take action. We're going to put teeth behind those lips. The teeth are going to be in the form of a $10,000 sanction. And we are going to continue doing this as long as people keep practicing law this way. If this be quixotic, so be it. Rocinante is saddled up, and we are prepared to tilt this windmill for as long as it takes. As you can imagine, language like that got attention.
Yeah, definitely.
And judges began saying, okay, there's a court of appeal that's going to back us up. If we take action against this incivility, there's now some case law out there. And I wrote 2 more opinions. There is an obscure civil statute that requires civil code. The joys of being 78. It's either the Code of Civil Procedure or the Civil Code. It's mentioned in LaSalle versus Vogel and ICRA versus, Specialty Products. Those are the other 2 cases. And that code requires that the parties cooperate. Says it black letter law. And I said, we've got to start enforcing this statute that requires cooperation. And to my satisfaction, other courts began doing it. And trial courts began saying, hey, finally, we're getting some backup. We can take charge of our courtroom. There are now 6 cases out there, maybe more. I mean, I've been away a year, in which courts have said this is unacceptable behavior and sanctioned the parties. My colleague, Tom Goethals, had a case in which the attorney admitted that his strategy for the settlement conference was to intimidate the other side. And he was a huge pain in the ass throughout the settlement conference. And the trial judge finally held him in contempt. And Goethals said, that's exactly what you should do in these cases. And the trial court said, wonderful, we've got a contempt possibility. We can use that as a weapon against incivility. I was never held in contempt. I always said, someday some judge is going to hold me in contempt, and I'm going to say, good, that makes us even. I never had the nerve or the foolishness to do it, but I told people for years, a contempt citation, the punishment is not the fine or even having it on the record. The punishment is all the work you've got to do to undo that contempt citation. There are going to be hours that the attorney has to put into that contempt citation to make it go away. And that's essentially a fine in itself. At whatever his hourly rate is, he or she will have to spend those many hours.
I want to stay with this for a minute, because the parallel to civility from our experience in the civil side is the games that get played in discovery. And one of the challenges that we find being both in federal and in state courts is, in state court, a side who wants to play games in discovery has learned that they can play games and there's rarely a sanction. And if there is a sanction, it's very minimal, usually below a reporting threshold.
Yeah.
And it seems to be that the judges...
The cost of doing business.
Yeah. Whereas in federal court, the judges do not screw around, that they will hand out sanction orders that get people to line up. And I'm curious about your experience on both as a Superior Court judge and as a justice, if you have any thoughts on why there's a difference between the two systems, why there's that issue with discovery in the state court.
There's a distinct difference between the state courts and the federal courts. Federal judges are lifetime appointees. They answer only to God and the Archangel Raphael, and Raphael needs an appointment. It's easy for them to slap a big number on a party.
Yeah.
They're used to making all kinds of orders that would stun a state court judge. I know a federal court judge who ordered the parties to rent office space because he was tired of them being late. They were both LA attorneys coming to Orange County, and he said, I'll give you a week to rent office space because you have abused my calendar so much. And that was considered something that federal judges do.
Wow.
I was astounded that somebody could do that. So you've got a very different idea about what the powers are. The state court judge is up for election every 6 years and needs bar support. And I don't know, I was never in that position. I was a criminal law judge, and then I came to the Court of Appeal and had a 12-year term. And, there's just not much you can do that people will remember and be offended by for 12 years. The civil court judges have to worry about how many people they antagonize. I tell young lawyers, one of the most important things that you have to do is, if not make friends, avoid making enemies. If you want to be a judge, you have to fill out this long, complicated, humongous application to which you are required to append the names of 50 lawyers who are familiar with your work. God help you if you don't have 50 friends, or at least 50 people that aren't your enemy who will fill out forms. One of my colleagues on the court, the appointment to the Court of Appeal was delayed for 3 years because the local bar ripped him, and the governor's office said, we really can't appoint you with this kind of response. Spend a couple of years making friends with the local bar and come back to us. And he did, and he eventually got to the Court of Appeal. But God, it's just, your life is just so much better if you're good to people. True story. Let me tell one
Please.
more story. I'm sitting in the calendar court, criminal calendar court. There is a terrific attorney in that court. He later practiced in San Francisco for many years. One of the finest criminal defense lawyers I ever knew, but a huge pain in the ass. Just treated people badly. And I'm sitting there, and he comes up to the calendar deputy, and he says, I didn't get my discovery. And I had heard this very same argument 3 minutes earlier from a very nice man, a man who everybody liked, yearly nominee for nicest human being on the planet. And he'd said, I don't get my discovery. And the calendar deputy said, oh, I'm sorry, Lloyd. What didn't you get? And he told the calendar deputy, and calendar deputy said, how much time do you need to respond? And he said, no, 4 weeks, 6 weeks. So they continued the case. And then the jerk comes up and makes the very same showing. I didn't get this, this, and this, exactly the same things the earlier guy had said he didn't get. And the calendar deputy looks at him and says, file your motion, Marshal. You want those things? File the motion. And I thought, here is this excellent lawyer, really a smart man. How has he never figured out that his life is so much tougher because he's not nice to people, because he treats them badly? And I saw plenty of lawyers like that who just, I don't know what their lives must be like. They're constantly at war. And I just don't think you hold up well if you're constantly at war.
Pivoting into the role in the trial courts, whether criminal or civil, I imagine there's some big egos, whether they're nice, jerks, disrespectful, what have you. How did you engage with some of the big personalities who I've been in courtrooms where a big personality will come in and try and eclipse everyone else.
I've got a big personality. When I was a young lawyer, I was trying to get evidence in and I was failing. Defense was objecting, it was being sustained. I couldn't figure out what I was doing wrong. I was trying over and over and over again. And the trial judge looked at me and said, Mr. Bedsworth, would you like a recess? And I said, no, Your Honor, I can tread water for as long as he can make it rain. And so I would get these people into my courtroom and I would say to myself, hey, if you're stupid enough to want to make this a battle between you and me while those 12 jurors are watching and deciding who they like, and they're going to like me, you go right ahead. And I would occasionally, at a sidebar or in chambers, tell a lawyer, you are making enemies with this jury every time you fight with me in the courtroom. You want to come up and fight with me at recess, that's fine. But you are not helping yourself in the courtroom by trying to overwhelm Ms. So-and-so on the other side and me. We had a judge who always wanted the parties to step out into the hallway and resolve this issue and come back in front of it. There are judges that we used to say, whoever speaks last wins. And, that's just a matter of personality, and you deal with that. You've got one affidavit of prejudice. If you're going into a weak judge against a big personality, then you might want to go elsewhere. But I don't have a magic bullet, I'm afraid.
Thank you for listening, and please join us next week as we continue this conversation. Please email us at podcast@coopers.law with questions, comments, feedback, and suggestions for who we should have on the show. Like what you heard? Share us with a colleague and leave us a 5-star review on your podcast platform of choice. To all of you doing justice out there, happy hunting.